and very good morning. So let's get started with the session while the others join us. Welcome back to the session for some of you who have been regularly attending the December sessions as well, and welcome to those who are joining us in the present session today. So the AIPR program is, as you know, a 6-month advanced intellectual property program where we have a combination of certain self-paced video courses where the participants would go through the videos and come and join us through these discussions. And then we have the live sessions, which are held mostly over the weekends on Saturdays and Sundays. So during the last, let me just give you a brief of what we did during the last December sessions and what we want to take forward during the February sessions now. So during December, we started off this subject of intellectual property rights with an introduction to the different forms of IPR to help professionals and budding professionals and startups understand what is intellectual property and what are the different forms. How do you identify the right forms of intellectual property for your given subject matter? And we also went on to conduct a sort of a workshop mode of sessions on procuring these intellectual property rights, like in the context of registration of intellectual property. We had sessions particularly on registration of patents, trademarks, copyrights, designs, etc. And so that was about identifying and registration of intellectual property rights. Now the question would arise: what next after you have you have the intellectual property registered? Does our work as lawyers or IP professionals end right there? Not really so. That's when the actual work begins, where you have to help your parties, help your clients to be able to commercialize this intellectual property to the best possible extent. They should be able to manage the intellectual property for the given term period of, say, 20 years for the patents, or 10 plus 10 years, or whatsoever for trademarks, etc., etc. So how are we going to work around commercializing these intellectual property becomes very, very critical, which is why today's session is dedicated to what we call as contract drafting, where we are going to look into various aspects of the intellectual property related contracts, technology transfers, etc., through this discussion today. So basically, we are looking at commercializing of intellectual property in its very many forms. In tomorrow's session, we are going to dedicate this completely for IP management, how intellectual property is managed by intellectual property firms or large organizations. You as intellectual property professionals, how do you manage the vast intellectual property deck that you would have or that your clients would want you to manage? So that's tomorrow's session is completely dedicated to intellectual property management, where we are going to discuss about IP docketing, IP due diligence, how is IP evaluation done, etc., etc. The next week, we're going to have 2 more sessions where the 24th session is going to be a very important session for most practicing lawyers, litigation aspirants, litigating lawyers, where we are going to be discussing about adjudication and enforcement of intellectual property rights. So we have a whole day dedicated specifically on the subject matter of adjudication and enforcement. And the last session, that is going to be on the 25th of February, will be on sector-specific areas of intellectual property rights. So there is a lot happening in the space of pharma and intellectual property. There's a lot happening in the space of entertainment and media. And there's so much happening of intellectual property in the digital age. So we're going to have industry experts and IP professionals who are going to give us an insight, a sneak peek into what is actually happening in the industry practice in the present world. So this is pretty much the structure that we have for the month of February, for the set of sessions that we are going to conduct during the month of February. And the first session is completely going to be dealing with the basics of contracts and contract drafting. And I'm very happy to invite Mr. Ashok, who is the instructor for the session today. Hello, Ashok. Good morning and welcome back to the session.
Morning, ma'am.
So for those of you who had not attended the previous session, a quick brief introduction about Mr. Ashok. So Ashok is the founder partner of Factum Law. He is a dispute resolution counsel, and he has represented clients in various food and beverage, healthcare, pharma, aerospace, defense and technology, banking, and various other services. His work in the field of intellectual property involves not only advising and assisting clients in protecting and commercially exploiting intangible assets, but also he represents clients in various IP litigations that involves trademarks, copyrights, trade secrets, etc. He has also had the distinction of securing several John Doe orders in the enforcement of trademarks, in addition to working with clients on the global intellectual property and cross-border enforcements. He is invited as a speaker in at various national and international forums. And very happy to also introduce that Ashok is, I think, the leading, according to me, he is the leading space lawyer in India. So welcome, welcome Ashok, and happy to have you here in the session.
Thank you so much, ma'am. Good morning, everyone. We will delve right into the subject. Now, before we kind of get into the conversation on contract drafting, just a few requests. I want to try and keep this session a little interactive. So if it's possible, there will be questions that are asked through the conversation. Please pitch in with your ideas, because I think contracts more than anything else requires imagination. And I think when we are able to stimulate ideas from each other, we are able to do a better job in putting the contract together. And the second thing, and this is only a request, if possible, please keep your videos on. I prefer to see the audience that I'm interacting with. If there's some difficulty, I completely understand. No compulsions, but it's good to have this conversation face to face, as opposed to just making it a phone call kind of a situation. Right. So without any further delay, let's get right into it. All right. How many in the audience come from a legal background, an LLB degree or a master's degree, or have probably worked with contracts in some capacity? Is there any insight or background experience in contracts that any of you have? Or,
I'm not from legal background.
Okay.
I'm not from legal background. Because I am from engineering background, so I am related to the basically FIDIC condition of contract, EPC contract, then in India in road infrastructures.
So mostly construction infrastructure agreements.
Yes, and at present I am working in Papua New Guinea. That is also it is in FIDIC condition of contract.
Okay, fantastic.
And, it is in road infrastructures.
Okay. And what about the other two participants, Tejal and Nagaraju? Have you had any background in contract law? Had some experience dealing with contracts, read the Contract Act?
Yeah, sir.
Hello, sir.
I'm just pursuing LLB now.
Okay.
I read about Indian Contract Act. Only the basics I know. That's it.
Perfect. And what about you, Tejal?
Hello, sir. So I've done 1 year of internship in corporate firm, where I had undergone drafting of few agreements, which are few agreements like employment agreement or software development agreement.
Okay.
So I have deal with contract, but I'm not very pro in contracts. I'm still learning because it was just for few contracts I've drafted. That's it.
Okay, perfect. That's completely okay. I think it just gives me a sense of the speed at which I can sift through the concepts, and also what I need to cover during the course of the next 1 hour. So that's the reason why I want to just understand the background of everyone. Okay, so let's quickly come to what the broad overview of today's conversation is, right? So first and foremost, what I will be touching upon today is a concept within contract law that I think is mostly ignored by most law schools in the country, which is the interpretation of contracts. Right? All of us have had probably some understanding of interpretation of statutes. There's a certain way to read a law. There's a certain theory behind how a particular kind of law has to be read, the purposive interpretation, the golden interpretation. So you have various subjects within the interpretation of statutes that are taught to you. But what is often a neglected subject in law school is the interpretation of contracts. And this is very, very critical, because while the Indian Contract Act might say things like offer, acceptance, consideration, restraint of trade, illegal object, it might give you the concepts of contract law. But to understand how a contract is to be drafted and what is to be borne in mind while drafting a contract, the subject of interpretation of contract becomes extremely important. And this subject is often completely untouched by most legal circles because it's not heard of at all. For me itself, it was quite a surprise when I actually came across a commentary on it. So the first thing that I would invite all of you to do as a recommended approach is to find a Sweet and Maxwell publication on interpretation of contracts if possible, and keep that in your custody, because what that will teach you in terms of how to draft contracts is priceless. Right? So we will touch upon the basics of interpretation of contracts. We will also be giving you some insights into recommended approaches on how to approach a good contract. We will deal with maybe one case study given the paucity of time and see if we can understand how these concepts play out in the context of an actual agreement you put together. What we will not touch upon, and I want to be very clear about this today, is we will not go into sections of the Indian Contract Act. We will not be touching upon things like novation, waiver, what is a unreasonable restraint of trade, what is a reasonable restraint of trade, what is consideration. These are things that will be extensively covered in the subject of contract law itself. Today, we are going to take a deep dive into the practical nuances of how the contract law works. Okay? So we will probably give you some basic insights into it, but the entire emphasis today will be on the practical nuances. Okay. So with that said, let me quickly jump to the next leg of the presentation. Now, in front of you, you will see the stock image, which is available on PowerPoint. So IP rights have been duly taken care of. You see a lady wearing a virtual reality goggles, right? Now, why is this image relevant for this discussion? Right? Because when we step into the field of drafting a contract, we assume, for whatever reason, that the principles of English contract law is what we have to keep in mind when we draft the contract. Right? So at best, we dwell into, say, how the United Kingdom's jurisprudence affects contracts. But most of us, we look at the Indian Contract Act, look at Indian law, and then say, okay, this is the approach we're going to take. Right? But the first thing that we have to do when we approach the subject of putting together a contract is we need to understand that depending upon what is the governing law that will affect the contract, right? Which is the governing law that will actually govern the contract itself, the attitude and approach towards the contract will completely change. Now, the reason why I say this is, let's take, for example, English common law. The emphasis in English common law is the contents of the contract, the language of the agreement, the words employed by the parties entering into the contract to arrive at a transaction or to enter into a particular arrangement. Now, let's move away from English common law and let's take a look at, for example, the Dutch Civil Code. Right? I recently had an occasion to litigate an arbitration before the LCIA, and the client was Dutch and the law involved was Dutch law. And there, the law does not really emphasize on the words employed either in the statute or in the contract. Under specified circumstances, a court in the jurisdiction of Netherlands can even amend or change the words of the contract if it feels that it can do complete justice to the dispute before it. As opposed to English contract law, which tells you that the words employed in the agreement is sacred and the scope of the dispute must be decided with reference to what the parties have agreed upon. No amendment or liberal interpretation is possible. So if you're going to take the approach of having English law, or American law, or Indian law, or Australian law governing the contract, or Singapore law for that matter, chances are that you will have to approach a text-centric approach to drafting the agreement. Whereas if you are going to have the contract eventually governed by the French Civil Code or the Dutch Civil Code or the Civil Code of some of the Middle Eastern nations, your attitude and approach to a contract will completely change. And the other example I can think of is English law has a fairly liberal approach towards termination of contracts. Under Section 14 of the Specific Relief Act, you even have something called as determinative contracts, right? So even if you don't have a termination clause, it's fairly easy to terminate certain kinds of agreements. For example, an agreement to provide personal services. under the concept of, say, the laws of the Middle East, specifically the Sharia, contracts have an entirely different sanctity. So even if the parties have agreed upon a termination clause within the contract, under the the UAE Civil Code, for example, the parties are not entitled to exercise that right of termination unless they go to the jurisdictional court and take an approval on the decision to terminate. So if you're drafting a termination clause in a contract and the governing law happens to be the UAE Civil Code, your approach towards the termination clause will completely change from what it was in, say, English common law. So the thing to remember is that before you sit down and actually put your hands on the keyboard and start typing or drafting the agreement, you have to first ask yourself, what is the governing law that I'm going to keep in mind while I put together the agreement? If the governing law is English contract law, you can fall back on all the conventional training that you have and put together the agreement. But if it is a different legal system that's going to govern the contract, your first and foremost task will be to unlearn everything that English contract law teaches you and step into the shoes of an entirely different legal system. Do the research necessary to understand how some of these clauses will play out, and then approach the agreement. Clear so far? Any questions?
I know.
The
I
next
just typed one questions.
Yes.
Like this, any contract agreement that whatever that I have reading generally just we can condition the FIDIC condition of contracts. So that as you are telling the termination clause. So termination clause, if we refer, okay, in my contract always it is happens that rule of the, law of that country should prevails because that the law of that country prevails. The termination clause generally we put it into the agreement itself in the particular condition of contract when we make it okay. These are the procedure and step we follow for the termination of contract. And then FIDIC condition of contract, like that is of course it is a global, everywhere it is used, infrastructures contract. So we make this contract specifically that should be followed. So in case of similarly, we are also using the FIDIC condition of contract and UAE. So the termination clause in defined in that FIDIC condition of contract itself.
So let's come to the question on that point, right? So let's, for example, assume that you are going with the standard form template, which is what FIDIC is in the context of, say, construction and infrastructure agreements. Now, a FIDIC contract may make a reference to a particular governing law to determine how the contractual rights and obligations will play out. So let's assume that the governing law is English common law, right? And the parties have agreed that English common law will determine the dispute. So then the termination clauses as defined within the agreement are sacrosanct. You follow the procedure, you're safe. Now, on the other hand, if the parties have deviated, from the template of, say, a FIDIC, right, a standard form template, and have decided to make the local law of, say, Saudi Arabia or United Arab Emirates the governing law. So then, for example, the entire construction agreement, there is a separate provision within the civil code which governs construction agreements only. It's called, I think, a mutawali contract, and for purposes of Sharia law. Now there, the relationship between the parties has certain sanctity that is attached by the Sharia, by virtue of which a termination clause cannot be easily exercised without cause. So it all depends upon what is the governing law adopted within the agreement. If the governing law adopted is the governing law that gives party autonomy the greatest respect and says that the parties have agreed upon a termination clause, that is what prevails, then obviously the courts can't interfere. But if the parties have adopted a governing law which says that, look, these agreements cannot be terminated for the asking because contracts once entered into is essentially a word of honor. And therefore, the court must really determine if the termination must be allowed or not. Then the termination clauses within the agreement have no value. And these things can get quite complicated because I was recently handling an arbitration before the DIAC, where it was an agreement that had the element of a transaction in property, a transaction for rendering certain construction and renovation services, and a contract for managing the business of the company. Right? So 3 different business arrangements captured under one composite agreement. The drafting language, the attitude, approach, everything was classical symptoms of an English lawyer putting together the contract. The difficulty, however, was that the UAE Civil Code was the governing law. The arbitration center was the dispute resolution forum, which appointed a German arbitrator. So you can see the complications. You're dealing with a European arbitrator, not trained in English law, dealing with a contract drafted by an English lawyer, where the governing law is the UAE Civil Code, which has elements of French Civil Code as well as the Sharia. Now, what ordinarily, it's very complicated. Now, what would ordinarily have been a fairly easy, because one of the issues was the termination of the agreement. Was the termination legal or not? And this dispute has been litigated by us for almost 2.5, 3 years now, and we're yet to receive the final award. Merely because the person who put together the entire agreement did not apply their mind to 2 things, one being the governing law, and 2, the jurisdiction. Because if you're going to, let's take one more example, right? As English lawyers, one of the things that we fall back on is what? Case laws. So if you're hitting a roadblock in terms of how a particular contract is to be understood. So let's take a example of an arbitration agreement. There is a recurring pattern of disputes in the courts where you have a specially negotiated agreement between the parties, which refers to a general terms and conditions. The general terms and conditions might or might not have an arbitration clause, but the specially negotiated agreement essentially refers to the arbitration clause and incorporates it by reference. Now, I had a situation where the specially negotiated agreement said dispute to be brought before the court only. You can't go anywhere else. But it also said that I'm going to borrow the general terms and conditions and make it part of the special terms. The general terms and conditions also has an arbitration clause. So you have 2 seemingly contradictory clauses. One that says you can litigate before the courts. The other says you have to only go to arbitration. Now, when you hit a deadlock of this nature, you go back and you see how the Supreme Court has interpreted it, how the High Court has interpreted it, and you finally come back and say, okay, this is what is the appropriate way of resolving the deadlock. But in a place like, say, which is governed by, say, the UAE Civil Code, precedents don't have the same value that case laws and decisions of courts in India have. So I don't even have the benefit of going back to a prior judgment of, say, the Court of Cassation in Dubai and say, okay, this is what the court holds in a similar situation, and therefore this is the way to resolve it. So the unlearning for an English lawyer is that basic. Even a dependence on the doctrine of precedents, we have to keep that aside and say, look, I'm going to be a first-year law student trying to understand the UAE Civil Code or the Dutch civil law. Then ask myself, how does this legal system work? Is there independence of the judiciary over, say, the executive and the legislature? Do they follow the same kind of jurisprudential systems that we follow? Do they believe in case laws and judgments, or do they not? Do they give more importance to the substance of the contract or the form and the manner? Are procedural laws as important? Are dispute resolution clauses binding and enforceable? So we ask ourselves these very fundamental questions when the legal system changes, unlearn everything that we have been taught and we have understood and we have practiced, and then approach it with a blank slate. And I'll come to the pitfalls of templates also, because the moment you refer to, say, standard form templates, they're very helpful in terms of cutting down time and entering into an agreement, but they're also a trap. So what those pitfalls are, we will deal with later in the conversation. The long story cut short is that always approach every agreement with a completely open mind, right? Just keep a blank canvas in front of you, take notes, do your research before you get into the agreement, as opposed to taking a template where the canvas is already filled completely, right? And then we change the parties' names and we change a few clauses in the consideration and a few other points and change the date and have the parties execute it. That is the incorrect approach, because all these nuances will be lost, right? So let's just keep this particular thing in mind. Unlearn before we learn, right? Now, it brings me back to the next question, right? Jurisdiction. Going back to the example of the arbitration in UAE, one of the things that made the whole enforceability of the contract as complicated was that the dispute resolution forum was the institutional arbitration center, which had a panel of arbitrators predominantly from Europe, not realizing that the governing law requires an understanding that a lot of European jurisprudence experts may not have. So there is a very interesting concept of how the law is understood in some of these Middle Eastern jurisdictions. You have a panel of experts in the law who may or may not come from, say, UAE or the country in which you're litigating it. They probably come from the Al Azhar University in Egypt, where they have been trained in the Sharia law. Now, those people are probably the experts in the law. But the jurisdiction and the dispute resolution clause refers to a panel of experts who do not have that qualification. Now, this is another example of what you need to keep in mind while you put together a contract, because where it is going to get enforced, who are the people that you're going to approach for enforcement of the contract, will have to determine how the contract is put together and what is the governing law affecting it. So these are all interconnected things. Right? Now, in our understanding, the easiest way to approach a problem is to take a linear approach, right? We understand who the parties are, we understand what the governing law is, and then we understand what the jurisdiction is. But in contracts, it never follows a linear approach. Everything is connected to everything. Okay? So if we are going to assume that the governing law will be first defined and then we're going to define jurisdiction, that may not be the right approach. You will have to first look at the whole picture and then see what is the best way each clause will complement and clarify the scope of the other clauses in the agreement. So never take an approach that says, I'm going to build a foundation first, the ground floor next, the first floor after that. When it comes to approaching a contract, you have to take a holistic view. It's a mind map, right? Where each module is connected to the other. And that's another fundamental shift in perspective that is needed when you come to approaching a contract drafting exercise. Because if you're going to say, let me start off by point A and slowly get to point Z, chances are that a clause at point Z is contradicting the clause at point A. And you won't even realize if you don't take a step back and take an overall view of the contract. Right? And that brings us to the very important point. To understand a contract, you have to read the contract as a whole. But if you're drafting the contract and you're not drafting the contract, keeping in mind the contract as a whole, then you're not doing justice to the exercise. The last thing to remember, especially in the context of IP, and today's session on contracts will take a very IP-centric approach given the overall theme of the course itself. Intellectual property has a certain life cycle, right? And there's always a curious paradox. Now, the value of your IP depends on how few know the IP itself, right? The fewer the circle of people having knowledge of the IP, the more valuable it is. Now, by that standard, however, if I keep the idea to myself and don't disclose to anybody else, that would be the ideal value for the IP because I'm the only person who has know of it. But unfortunately, we can't monetize the IP unless it gets out of my head and into the market. Now, this is the paradox, right? I have to keep it to a limited circle, but for me to become successful, I need to ensure that it reaches the public at large. Now, how do you balance this seemingly contradictory priorities, right? Where value of the IP is in the circle of knowledge being limited. At the same time, the monetary value is only realized when it goes out to the world. This risk that every IP owner takes by putting the IP into the market, that is managed by two instruments, right? One is the law, the other is a contract. Because the bridge between monetization and ideation of IP is always the contract. You monetize IP through licensing, assignment, technology transfer agreements. You can call it as whatever nomenclature you want, but ultimately it's that imagined set of ideas around the intangible asset captured in an agreement, which will ultimately ensure that an idea actually becomes valuable and gets you money. So keeping this commercial perspective in mind is very, very critical because one of the ways in which the contracts are interpreted is also to see what was the commercial objective and then to see what the meaning of the terms employed are. So 3 things to keep in mind. 1, the governing law. 2, jurisdiction. 3, the fact that between ideation and monetization, contract is the bridge. Right? Now, I can't emphasize this enough, right? So what you literally have to do is before you enter into a contract, you need to wear a spectacle which contains 3 lenses: the governing law, the jurisdiction, and the commercial objective of the agreement. These are the lenses through which you will start drafting the contract and the lenses through which you will understand and read the clauses you have drafted. Right? Any questions thus far? Okay. Now, this VR headset that you see in the picture, that VR headset is essentially the research that you undertake into the governing law. Right? So if you, for example, have to step into the shoes of a Dutch civil lawyer, that's the mode that you're going to activate in your headset. Right? If you're going to approach it as an English contract lawyer, that's the mode you're going to activate. You're going to approach it in the MENA region, you're going to adopt the headset that gives you the perspective of Sharia law. Right? So keep this in mind because the next leg of this conversation will increasingly fall back onto this. Right? Okay. Now, what do you have to keep in mind? We discussed the basics, right? The 3 lenses that we have to bear in mind through which we look at the contract. The first thing we have to understand is contract is communication. Okay. Now, contract is communication, fantastic. But the communication, what makes it even more complicated, especially if you're going to approach it from the lens of English common law, it is not the communication between the parties to the contract. So if, for example, Dr. Pratima and I enter into the contract, right? The contract is not just a tool for me and her to communicate with each other what the terms of the agreement are for me to take this class. Right? Essentially, the communication is also with a complete stranger to the agreement. For example, if Tejal is the stranger to the agreement, this contract that I'm entering into is a tripartite exercise of communication, right? Where Dr. Pratima and I enter into an understanding of what is the terms of the agreement. But I can't sit with Tejal and tell her that, look, this was the understanding that Dr. Pratima and I had. That's why you should read this clause in this particular fashion. Neither will Dr. Pratima have that occasion to say that, look, the ambiguity in the contract is to be resolved by virtue of the fact that Ashok and I exchanged this email in which we have understood that this is the way this agreement has to be understood, right? Because what Indian law, what English common law, and what all common law countries emphasize on, and this is a trend that is now becoming increasingly universal, because a sizable number of international commercial arbitrations are English common law centric. So why this becomes very important is because Tejal is expected to gather what the understanding between Dr. Pratima and I is based only on the reading of the contract, not based on any clarification she might have with either me or Dr. Pratima. So if we don't enter into a sufficiently clear contract, Tejal's difficulty will be that she has no manner of approaching either Dr. Pratima and I to understand what was the intention, right? Our intention has to be gathered only by the terms of the agreement in the language captured in the agreement. Nothing else can be looked into. Right? Now, while looking into the language of the agreement, there are various theories and principles applicable for interpretation of a contract. Right? The first theory, which is the most popular theory, is what is called as the linguistic theory. Linguistic theory gives primacy to the language of the agreement. Okay. So which means whatever is the language of the clauses of the agreement, that language will prevail. Now, obviously, that means you have to gather the meaning of the words. How do you arrive at that meaning? Some words have an objective meaning, right? So it's very easy to gather. You don't have to really break your head into understanding what the terminology or the word means. Right. And to give you a simple example, legal heirs, which will be used to define the parties. There's a fairly objective meaning as to what a legal heir is. It's a successor of a person. Now, the objective meaning is well understood. You really don't have to worry much. So judicial notice and objective meaning is what is available to you. Sometimes the language may be beyond what the objective meaning that's generally known. That's when you fall back onto dictionaries and contextual evidence, right? So certain words, for example, can have different meaning depending upon the context of the agreement, right? So, for example, the term determine could either be to say that I'm applying my mind to a certain, question in front of me and arriving at a conclusion. Determine can also be to terminate. Right? So here is a classic example of a word having two meanings, depending upon the context in which it is used within the agreement. You can either gather the meaning that says I'm arriving at a determination or a conclusion onto something, or that it refers to my right to terminate. So, for example, if the contract clause says the parties agree that this contract shall by its nature be determinable, then you know that the reference is to the terminable ability of the contract. But if the contract says that the valuation to be applied to the IP shall be determined by party A, then you are referring to the meaning of the word determine, which refers to conclusion. So the context in which the words are employed in the clauses also makes a lot of difference. And it's useful to know that when you have these kind of situations, don't wait for the context to be gathered by virtue of an adjudicating process. Try and supply the context within the language of the agreement itself. So if you have ever read the contract and if you have ever gone through a definitions clause, you will always see that unless repugnant to the context of the subject matter thereof, the parties agree that the following terms shall have the following meanings. Right? Now you understand why the phrase unless repugnant to the context or subject matter thereof is employed. Right? All of the templates that you have frequently come across fall back onto these principles. Right? What I'm telling you right now is what is the equivalent of 2 plus 2 is equal to 4 for mathematics, right? That's how fundamental these principles are. So when you're reading an agreement, especially for all the students who are yet to get into the industry or to yet to kind of come face to face with the challenges of drafting a contract, these fundamentals are how you ensure that what you're reading actually makes sense and that you're not just putting in things that may or may not even be relevant, right? So theory one or principle one, linguistic theory. The second theory is what you call as the object theory, right? What is the object of entering into the contract? Yes, sorry, somebody had a query.
Yeah, regarding linguistic theory approach, I had a query regarding the context, what we have written in the drafting may subject to change other person if the other person reads the same context. I mean,
So-
how the language should be. Is it in a normal way or should be in a how it should be drafted?
So see, the challenges of drafting a contract also is for sufficient clarity, you want to take liberty with the number of words you're employing. But B, the longer the contract is in terms of how lengthy it is, it's also becomes more difficult for the parties to understand, negotiate, and execute the contract. One. And two, at the time of enforcement, the challenges that the parties had in understanding the contract, the judge will have the same challenges. Right? So in terms of how do you define the context, you define the context. So one of the things that I do is I give an illustration. Right? So if I feel that with the best of efforts, I'm not able to ensure that the clause in the agreement is self-explanatory, what I do is I say, okay, to give an illustration as to how this clause is understood and defined in the agreement, this is the illustration. So within the agreement, you have the clause, you also have the illustration, and therefore the context becomes a little more evident. Right? So there's no straitjacket formula that this is how it is to be done. Obviously, one of the things that you will have to work on as a skill set is develop your language. Because to be able to say a lot using minimal words is a function of your vocabulary, it's a function of your grammar, it's a function of essentially the ease with which you are able to convey ideas. And that requires a high degree of emphasis on development of language. Right? So is there a clear-cut answer that I can give you that will work in all respects? No. But there are some examples, right? The illustrations are one way of supplying context, which tomorrow will not be a subject matter of dispute. Does that answer your question, Nagaraju?
Yes, sir. Thank you.
Okay. So the next principle is what we call as the object theory, which is when you look at the objective of entering into the agreement. Okay? Now, bear in mind in day-to-day commercial trade, not every transaction is elaborately negotiated and an elaborate agreement is entered into. even in the context of, say, purchasing a software license, sometimes the entire agreement is just one purchase order with 4 or 5 terms and conditions. Right? So in a situation like this, a lot of things are left for the interpretation of the courts. And to arrive at the understanding of what the actual intent of the parties is, sometimes the courts will also go into the objective of the contract. What was the commercial benefit that the parties were trying to realize? Right? And that will then be one of the things that the court will consider while arriving at the intent of the parties. Right? So the next theory, of course, is the purposive theory. Right? So what was the reason why a particular clause was worded a particular way? Right? Was the intent to make it easier to party A or make it more difficult for party B? So the purposes of the entire wording of the clause is one of the things that will be looked into. Now, American jurisprudence also makes reference to the subjective theory, where they say that, look, forget about what the agreement is understood by a stranger to the contract. We will also examine what the party's understanding was while entering into the agreement. Right? Now, this is not universally true for all common law jurisdictions. Only American jurisprudence seems to be giving some emphasis on the discussions and the negotiations between the parties, the meaning of the words as understood by the parties. So, in the subjective theory, for example, sometimes the universal meaning of a word will yield in favor of the meaning of the word as understood by the parties. Right? So it can happen that way under certain situations in American jurisprudence. But this is not popular either in India or in the UK or in Australia. So again, going back to the question of governing law that you employ while putting together the agreement and the dispute resolution forum, you also have to keep in mind this aspect before you enter into the exercise of drafting the agreement, right? Because if I am drafting an agreement and the governing law is American law, right, and the dispute resolution forum is, say, the courts of law at Houston or Delaware or New York, I have to be constantly mindful of two things. One, arbitration is not something that is preferred in the American system, right? Domestic arbitrations in America are almost negligible in number for the simple reason that the courts of law are quite efficient. Same is the trend even in the United Kingdom. Right? So chances are that your dispute will go before a local court if the governing law and dispute resolution forum is the US. And I have to bear in mind not a judge who's trained in the law, but an ordinary jury member. I have to draft that agreement keeping in mind what that ordinary jury member, who could very well be a plumber, right? And tomorrow the complex IP licensing agreement for, say, a mobile phone technology could very well come before a plumber in the United States to determine if there is a violation of the license terms or not. So keeping this in mind, the simplicity of the language will have to adequately to mold. So contract is imagination, right? So if you're going to have a contract in a, say, an IP licensing agreement with American law being the governing law dispute resolution forum, you have to have the imagination of stepping into one of those typical, I don't take this the wrong way, but an average hillbilly supporter of Donald Trump, and then ask yourself, will this complex IP licensing transaction be understood by that person when he's sitting in the jury pool trying to determine if there's a violation of the license terms or not? Right? And this is not an easy exercise. This cannot be done casually, which brings me to the problem of templates, right? Because what templates do is that it completely disincentivizes this imagination that you need, right? Because it's easy. You borrow something off the internet, you borrow something that's in a book, type it out as it is, change a few clauses, game over, you make your money. But this nuance, which will only be necessary when things go wrong, templates will let you down. And that is when the parties are going to go back and say, who is the person who put together this entire agreement? Why did they not think of these things? Right? And that's what you're trying to avoid when you apply your mind to drafting an agreement. Clear so far? Any questions? Okay. Now,
So I have
yes,
one
Teja.
question.
Yes.
That is not directly related to the clauses, but when we talk about not to use templates while drafting contracts, so sir, nowadays a lot of AIs have come up, and people do tend up to draft clauses of their contract, not the entire contract, but they do take the help of AI for their to draft their clauses. So, how is that a correct approach, or if it is correct, then up to what extent we can use it?
Great question, Tejal. So, as part of the pitfalls of templates, I was also going to address the new problem of artificial intelligence, specifically ChatGPT. Have any of you heard of this gentleman called Stephen Schwartz from the United States? Okay. So Stephen Schwartz is currently under investigation by if I'm not mistaken, the New York Bar Association for potential malpractice, for the reason that this gentleman, in a dispute that he was representing a client in, went to ChatGPT with a particular proposition of law on summary judgments, if I'm not mistaken, and then said, give me 7 or 8 citations from different state court of appeals that will support this proposition of law. Right? So ChatGPT scanned the entire length of the internet and managed to deliver 7 citations, dot on the point. So Stephen Schwartz was extremely delighted. And if you ever get the chance, I would invite you to go and read the PDFs that were generated by this ChatGPT tool, right? It's superbly done. The only problem being that when this was cited in court and the counsel on the other side had a chance to go back and examine what these case laws were all about, they could not find these judgments at all. So ChatGPT understood the command to say, don't look for judgments, essentially give you judgments, right? So it just generated the judgments on its own, 7 citations, Illinois Court of Appeals, variety of Court of Appeals, appearance-wise, fantastic, very authentic, parties' names, docket number, everything mentioned. Right? But it did not exist in reality, right? And now Stephen Schwartz is under investigation for possibly being the first victim of ChatGPT. Right? And imagine his problem now. Forever in history, he will be known as the first lawyer who was taken for a ride by artificial intelligence. Right? Now, AI precisely has this problem, right? you have to really understand what AI is capable of doing. There's a wonderful book called Oxford Handbook on Artificial Intelligence Ethics, and I would invite all of you to read through that to understand precisely what is artificial intelligence. There is a huge difference between autonomy and automation. Okay. And I want the distinction to be very well understood. Artificial intelligence is about automation and not autonomy, right? It is still not in a position where it can, independent of data available from history, generate ideas on its own, right? But what it does is it does automation very, very well. Right? So routine tasks, right? Things that are repeatable, things that need not really involve that same level of human effort at ideation. Artificial intelligence is a great tool for you to use to ensure that those mundane tasks that can be repeated, that need not involve application of mind, you're able to use artificial intelligence for your contracts for that. Right? So to give you an example, if you want to generate a non-disclosure agreement, and non-disclosure agreements are fairly standardized, you can go to ChatGPT and say, look, this is the context, this is the requirement. Can you give me a template of a non-disclosure agreement? Now, what ChatGPT will do is it will save you the trouble of having to type out the clauses from scratch and give you the broad terms and conditions, right? But then it is for you to look into it, right? Because now you have had the time saving of having to type the agreement from scratch. So what you then do is you invest the time into review of the clauses. You invest the time into research into the governing law. You invest the time into understanding the commercial objective of the parties into entering into the non-disclosure agreement. Is it discussions preceding a business contract, or is it the confidential information exchanged after the business contract is already signed, right? So you invest into your efforts into those things, and then you come back and review the template. So how do you kind of integrate AI into your life? My personal approach is to do this, right? If a contract takes 1 hour, 45 minutes of which is going to go into typing the agreement, 15 minutes into review, and I'm saving, say, 55 minutes out of that entire exercise for generating the template, right? So I have the next 55 minutes to essentially do everything else. That is what I do with my time. I do research. I do a more thorough review. I have more conversations with the clients to understand what the clauses are meant to be, what is the commercial arrangement. But if I tell myself that, look, out of 1 hour, I've saved 55 minutes. So within the next 55 minutes, I will do maybe 10 or 15 other agreements. That's a bad idea. So AI is great, but knowing the limitations of AI is essentially 90% of the problem statement, right? And for that, you have to first understand what artificial intelligence is about. What are the ethics of using AI? What are the limitations of AI? What are the strengths? How can they work with the legal fraternity? All of this will then help you understand the role of AI in terms of contract drafting. But if that understanding of AI itself is a little simplistic and not thorough enough, then chances are that AI is going to become a trap and it's not going to become a tool. So it all depends upon the amount of effort you put in. And AI requires its own effort. It requires a different kind of effort. But yes, what it does is it helps you automate a lot of things. Right? So never assume that AI is that lawyer of 30 years experience who you can go to with a query and it'll answer and it's right. It does not substitute a lawyer. It only substitutes a glorified typist. Right? So does that answer your question, Tejal?
Yes, sir. Thank you so much.
Okay, so what does this eventually come down to, right? And AI is also very important for the reason that you will increasingly need agreements that are machine readable, right? Especially if you're going to, for example, get into the subject of digital rights management, which we'll be separately addressing. You might have situations where the contracts you're putting together may have to be easy and simple enough to be understood by artificial intelligence so that whatever is the consequences that follows from a contractual compliance is undertaken easily. So clarity of mind and simplicity of language, the two things to keep in mind, right? Now, simplicity of language also has another pitfall, right? You also need to be very clear about one thing. Simplicity of language is not just simplicity of language between the contracting parties, right? FIDIC is a classic example. FIDIC template in the world of construction, you will have everything so well understood by, say, the project management consultant, the developer and the employer, or the contractor and the employer, that half the technical jargon will probably not even have to be separately defined. Right? So let's take the example of the use of the nomenclature employer to define the principal developer of the project. Now, employer in a layman's term has a very different meaning versus the employer in a construction agreement. Right? Now, never take it for granted that the terminologies that are well understood in the industry are capable of being incorporated into the agreement as it is without meaning or context. Because tomorrow, the person who is enforcing that FIDIC contract, chances are that he's a judge with no civil engineering background, never stepped into the construction industry. Can he understand the language of the contract, right? So my way of looking at it is look at it as the lowest common denominator. The Trump supporter that we were thinking about, or the average person with not the greatest hold on the English language, that is the audience to which your agreement appeals to, right? And that is the simplicity of language you're trying to achieve. So the simpler, the better. And in that endeavor, the contract can always be better, right? This is the one rule that you need to keep in mind. No matter how good your contract is, there's always a better way to put it across, right? That's the perfection that you try and achieve. Okay. Now, coming to the governing law, it's also very important to realize that governing law has a huge impact on the recognition of the asset at the core of the IP transaction, right? Now, let's, for example, assume that we enter into a contract for a technology or an invention, which is predominantly a business method patent. Okay. Now, the standard of business method patent in the US is vastly different from the standard employed to determine business method patents in India. In India, they're virtually unprotectable unless you're able to show a physical, tangible invention or innovation. Right? Now, if you have an elaborate agreement, right, and let's assume that you have an American client. The American client comes to you and says that, look, I have a business method patent. there's an Indian licensee who's interested in acquiring the business method patent for use in India. Help me draft a patent license agreement. Now, the lawyer gets into the business of drafting a phenomenal patent license agreement, neglects to mention anything about confidentiality, about non-compete, so and so, and then ultimately makes the governing law as the Indian law, right? Or even the UK law. Now, the agreement is entered into, the licensor transfers the know-how to the licensee. The licensee understands exactly what the business method patent is, terminates the contract and starts using it in India without payment of royalties. Now the licensor comes and says, hey, I had an agreement, he's terminated, he's blatantly infringing my business method patent, help me enforce it. Now the lawyer, the litigation counsel in India will tell you that, sorry, business method patents don't even have recognition under Indian law. You have no confidentiality clauses inserted to protect the know-how around it. There's no non-compete clause around this. So I can't help you, right? You're essentially completely bereft of any remedy, right? Now, why did this entire exercise happen? Because the lawyer in, say, Mississippi neglected to ask himself that one question. The IP at the core of my IP transaction document, is it even recognized in the governing law that will determine the arrangement between the parties? Right? If that question was not asked, then chances are that the definition of IP itself has been incorrectly framed. And therefore, the enforceability of that IP contract is almost slim to none, right? The other example that I can think of is in the context of a copyright assignment agreement, right? Now, let's assume that the work is yet to come into existence. And this is very common in the movie industry. The cinema is yet to come into existence. A script is conceptualized, a title to the movie is there, actors have already been appointed, the shooting is probably underway, the production is underway, but the final film is yet to come into existence. Right? So the broadcasting channel comes to the movie producer and says, I want to acquire the rights to the movie once it comes into existence. Right? So they enter into an agreement where a sum of money is paid to essentially say, once the movie comes into existence, we will then look at entering into a binding agreement for broadcasting rights. Right? And then they neglect to enter into that detailed license agreement for the broadcasting rights. Right? Now, there are circumstances under which this is enforceable as an equitable assignment or an equitable license. But what has happened is that this form of an agreement, without the follow-up agreement in writing with the terms and conditions of the license, may not be enforceable or cannot be treated as a transfer of IP rights itself, because there are mandatory requirements for assignment and licensing transactions to be registered, to be put in writing, right? So these things not being taken into account while drafting the agreement can essentially defeat the entire agreement itself, right? So sometimes the options are also restricted by domestic law. So you have to ultimately fit your contract within the realms of the governing law. The other thing is the remedies also that you are stipulated within the contract gets affected by governing law. I will give you a simple example of liquidated damages. Liquidated damages, you will also notice a standard form template in FIDIC contracts as well. Now, liquidated damages clause under the UK law is enforceable simpliciter. A sum of money is prescribed if it doesn't seem on the face of it like a penalty, right? It doesn't come off as in terrorem. Then the UK courts will say, regardless of the actual losses you have suffered, the liquidated damages will be awarded to you. Indian law, on the other hand, says that you have to prove the actual losses you have suffered. And if the liquidated damages clause is commensurate with the actual losses you have proved, then only you get it. Right? So most people enter into a liquidated damages clause with even a stipulation that says this is a genuine pre-estimation of the losses, not realizing that it doesn't take away the obligation of proving losses. And the most common example is breach of lock-in periods in rental agreements. Right? They're not enforceable unless you can show that the actual losses you have incurred by the breach of the lock-in period is commensurate to the penalty specified. So knowing the impact on the damages or the remedies is also very critical. And bear in mind, sometimes the right to terminate the agreement itself is a remedy for a breach. Right? It is one of the forms of remedies available. So like we discussed the case study of the UAE Civil Code, sometimes your right to terminate a licensing agreement itself could be suspect. It may not be enforceable, right? Or it could be subject to encumbrances. So that is something that you'll have to address in your agreement, right? Same thing with limitation of liability. Sometimes you have agreements that imposes an upper cap on liability, but Indian law has not enforced this limitation of liability clauses simpliciter. It's always subject to terms and conditions, right? Never take the clauses in a standard form template for granted. Examine enforceability of each and every provision in the agreement, right? If you don't make that exercise, you put in clauses, you goad the parties into a false sense of security. And I'll give you an example. I'm currently litigating an IP dispute arising out of a licensing agreement for a cinematograph film as well as a musical work. It's a music video. Now, the agreement said that a sum of rupees 2,75,000 rupees is being paid to the performers to shoot this music video of a live concert. The agreement also says that the beneficiaries of the music performance, which was during COVID, is going to be the audience of a particular organization, employees of a particular organization, and they have the right to watch the video once, right? What happens if they watch the video more than once? The agreement says for every subsequent view beyond the first view, a penalty equivalent to 500 times of the sale consideration will be payable for each view, which means I watch it the second time, 500 times of 2,75,000. I watch it the third time, 500 times of 2,75,000. Now, surprisingly, and I will not name the firm involved, a very reputed law firm sent my client a notice asking for 500 times of 2,75,000 for each view undertaken by the organization's employees, right? And the funny thing was they even got the mathematics wrong. They asked for 13,75,000 for each view, whereas it was actually much higher than that. 500 times comes to around 13 crores, 75 lakhs. So this notice was even followed up with a plaint for infringement of IP and for enforcement of the agreement. And the first thing that we said was that, look, unless they're able to show that the actual losses is 13 crore 75 lakhs for each subsequent view, the liquidated damages clause is not enforceable, number one. Number two, they wanted an injunction restraining me from viewing it further. But in Indian law, if the harm is capable of being remedied by damages, injunction cannot be granted. So we said that, look, the agreement itself has a liquidated damages clause, which shows that monetarily this harm, if any, can be addressed. So where is the question of grant of injunction? Right? And the third most important thing is that the musical works that were performed were not original. They had already been performed by popular Bollywood music composers and singers. This was a rendition of it. Now, there's a separate license to be taken for this, for even a rendition of an earlier song, which was not taken. So we took the fruit of a poisonous tree equivalent defense, which is that when it's not the original work and it is a derivative of a already existing work, the party has to make the original copyright owner a party to the proceeding, failing which is not maintainable. So the entire suit came to be dismissed only for this one reason. So, the application for injunction came to be dismissed. The suit is still pending. And chances are that the suit is going to get rejected now. Now, imagine the horrors of the musical performers, right? They thought they entered into a watertight agreement with a highly deterrent clause, only to realize this entire exercise is falling apart like a pack of cards the moment it goes to court, right? When you don't keep in mind the governing law and its impact on IP rights, this is the problem that you're likely to encounter, right? Any questions so far? Okay, now coming to... yes, lady.
So I just want to ask something, that what should be the exact clause according to you to be entered into the contract or agreement which could provide us from the issues which we discussed?
So, see, the ideal form of a clause depends exactly on what is the commercial arrangement between the parties. So let's assume, for example, it's a movie that's come into existence and the broadcasting rights are being negotiated and you're drafting an agreement for it. Now, essentially here, the first and foremost, you're looking at identifying the IP, right? Because in the context of that cinema for which you want the right to broadcast, there is the rights of performers within the cinema. B, there is the right of the musical composer. There's a right of the lyricist. There is a right of the singers, right? There is the right of the script writer, of the dialogue writer. So you have literary work, you have musical work, you have so many of these things. So you have to first define the IP correctly and ensure that it is exhaustive enough to cover the full range of rights within the cinema. Two, you want to identify what are the rights you're acquiring, right? So you have the right to broadcast, great. But is it broadcasting on over the top platforms like say Netflix? Is it for television channels, right? Or is it for some kind of a platform for broadcasting that's going to emerge in the future, which you are not even able to contemplate right now, right? And I'll give you a simple example. A movie shot in 1991 in Kannada film industry, which is a very, very popular movie, been running for decades in the cinemas now. The rights were sold to a particular person in, say, 1991. Now, that agreement was entered into at a time when the concept of internet was not known in the country, leave alone over the top platforms like OTT platforms. Now, thankfully, whoever put together that agreement said that I have the right to broadcast not only on broadcasting platforms that exist today, but which may come into existence sometime in the future, which we are not even able to contemplate right now, which enabled him to get a killer of a deal when he sold it to OTT platforms, right? So the question of what is an ideal clause is the idealness of a clause is only limited by your imagination, right? So that's where the blank canvas arrangement is what is ideal. You want to sit down with a completely open mind and ask a ton of questions to your client, right? So what is the right you're acquiring? Okay, so it's a cinema. Who is the movie producer? Who is the script writer? Who is the cinematographer? Who is the cameraman? Who is the music composer? Who is the singer? Right? What is the contribution by each of these parties? Please name the work that they've undertaken. Is there agreement between the producer and all these stakeholders to ensure there's a proper transfer of title? Right? So you ask, understand the questions, understand the questions first, understand the answers to the question later. Then you ask yourself, what is the intention of acquiring the broadcasting license? Is it to give you rights for 2 years? Is it to give you rights only in India? Is it to give you rights globally? Is it to give you rights only over, say, OTT platforms? Is it to give you rights over the television channels? So you ask a ton of questions, and then you ask yourself, what is the ideal way to draft that agreement? So that question essentially is so broad and so relevant that it is a conversation that you and I will have to have repeatedly based on what the actual requirement of your client will be, right? But right now, I can only give you the methodology, which is ask these questions, know the governing law, know the impact of the governing law, right? The process of how you do this is what we can give you right now. Does that answer your question?
Thank you, sir. Yeah, sir. Thank you.
Okay, perfect. So now, what do you keep in mind when you draft an agreement for IP transaction, right? First and foremost, you understand and appreciate what is the IP. For that, your understanding of IP has to be crystal clear, right? So, for example, we had a very interesting scenario where I was negotiating a technology transfer agreement between a company located in the Asia Pacific region with an potential Indian licensee here, right? Now, when the agreement came to us, the definition of technology was referred to in Schedule A, and it was kept blank, right? We didn't know what the technology was. We negotiated the terms of the technology transfer, the restrictions, the limitations, what is possible, so on and so forth. And then we sent the agreement back with a clause that said, please define the IP and resubmit it for the next round of review. And I got that agreement. And to my horror, the definition of IP, and I'm not even making this up, one of the technologies defined was greeting customers with a smile, right? This is defined as IP and this is defined as technology. And the agreement also says that after the agreement terminates for a period of 2 years, I can't do business involving that same technology. And the question obviously then is, am I not allowed to greet customers with a smile in case the agreement is terminated, right? And again, a very big name on the other side of the transaction. So obviously we raised a huge red flag saying that, look, even if I call this technology and I subject this to license restrictions, it won't be enforceable because no court on the planet is going to tell me that I can't smile at a customer, right? So what is it that you're getting into? Now, the complication here is that the party on the other side from the Asia Pacific region is not English speaking. My parties are English speaking, right? The lawyers are Indian lawyers trained in English law who can speak English, right? And we are trying to bridge all these different worlds between two different cultures, two different languages for transfer of technology. And after a lot of questions, that spanned across our conversation that might have maybe gone in excess of 5 to 6 hours, we finally realized that the actual technology that the Asia Pacific partner was interested in protecting was a certain innovation in supply chain management, right? The movement of materials from point A to point B, they had achieved certain improvements and efficiencies in that using certain algorithms, right? Now, this was later sought to be protected as an invention. But invention is not IP. Invention is protectable as IP under certain categories. So we again went back to the drawing board and we said, can we look at defining this as know-how and confidential information, which was finally appealing to all the parties. And that is how the technology transfer agreement was finalized. Right? Now, why is this important? Because when you have as many barriers between people, between cultures, and between languages, understanding of IP will also vary vastly, right? It is for the lawyers then to have those moderated conversations with the parties to understand precisely what is the IP and define it in a manner that is protectable and recognized by the governing law. The next thing that you also then want to identify is the context of the parties. You would notice in the preamble of every agreement, you will have a clause that says whereas. Right? Now, why do we come back to whereas, where we explain the background to the transaction? The reason is if you go back to this part, we looked at two things, right? The object of the contract, the contextual evidence, and the purposive theory. Now, what this whereas clauses do is that it defines the context of the agreement. It defines the context of the parties, right? You're essentially setting the stage for a potential scenario where one party may come back and say there was undue influence, right? In non-compete clauses, employees will complain that there was undue influence. They felt they had no choice. But by defining the preamble or clauses in a manner that explains the context of the parties, the setting of the parties, and says that, say, after detailed terms and conditions discussions, the parties are now entering into this agreement voluntarily and with an acknowledgement that there is sufficiency of consideration, you are preempting undue influence, right? You're also then ensuring a certain enforceability and a certain context for the potential reader of the contract to know why the parties entered into this agreement and therefore understand why the wording of the agreement is what it is, right? So the context of the parties in the background becomes very critical, and especially in an IP scenario where you have, say, an individual music composer with a big production company, right? Chances are that the music composer may think that he continues to retain certain creative rights over the work and use it in a slightly modified manner at a later date, right? So to be able to later preempt a defense from him saying that, I was coerced into this and I felt I had no other choice, the preamble of the agreement is very, very important, right? And throughout the agreement, you need to ensure that the context is adequately captured. Then you want to capture the business case, right? The business case is what? The geographical extent of the rights granted in the IP, the industry verticals or the platforms over which the right is granted. So if you ever do work with a copyright society, like the Indian Performing Rights Society, they will, pending the whole litigation and decision around whether IPRS can even do the business of a copyright society or not, what IPRS did, and along with a whole bunch of other copyright societies like Novex, is that they said until the decision comes out about the tenability of our existence as copyright societies, give us assignment of the IP rights, right, over the particular musical work. We will then, as assignees, look at enforcement. Now, some of these assignment agreements, if you study them, and you'll find this on the website of the relevant copyright society, there is a region granted in terms of the license to the copyright society or assignment, right? So it's defined as, say, India. Between that, you will notice that one copyright society may have rights in respect of musical works being played in hotels and restaurants, but not the right to license work in, say, commercial office spaces. So even the potential pool of customers that they can reach out to is limited within the business case of the agreement, right? So the license rights are that nuanced and that layered. So the business case has to be clearly understood. Obviously, the licensor wants to get a lot of money for giving very little. The licensee wants to get a lot of rights by giving very little money, right? So it's the exact opposite. The licensor wants more money for less rights. Licensee wants more rights for less money. Same thing with an assignment. So how do you fairly balance it out? You can give parties a variety of permutations and combinations. Geographical extent is one way to do it. Channels of trade is the other way to do it, right? Industry verticals, customer verticals, transaction sizes. I mean, again, you're literally limited only by your imagination, right? And then once you've defined all of it, you have to obviously ask yourself, is it enforceable under the terms of the Indian Contract Act? Have I put in something that is an unreasonable restraint of trade? Right. So, for example, an agreement that says that you will only do my films, and if my performance rights agreement with you is terminated, you will not work with a production house other than mine. That's an unreasonable restraint of trade under Section 27 of the Indian Contract Act. So sometimes a lot of collateral laws will also apply to these transactions in IP. Right. If it is a holding company transferring technology to a subsidiary company in India, you have to ensure that the way in which the licensing consideration is defined does not fall afoul of transfer pricing considerations under the Income Tax Act. Because the moment that happens, then you have a huge tax liability that you're staring at, right? And you can look at transfer pricing issues and how big it became in the context of a Vodafone tax judgment. Thousands of crores of liabilities, right? All because of related party transactions. So be very careful. A contract lawyer, unlike say an IP enforcement lawyer, and I hesitate to say that an IP enforcement lawyer can be an exclusivist, but a contract lawyer has to know everything all the time. You are not having the luxury of becoming an exclusivist. You can be a specialist. There's nothing stopping you from knowing one subject more than the other, but you need to know enough of everything to know the known unknowns, right? So you need to know enough tax law to say that if the licensor and the licensee are related parties, I need to point the parties to the direction of a tax lawyer or a chartered accountant so that the transfer pricing component of royalty and the consideration is addressed. Okay? So knowing everything all the time is the requirement, right? We can never be perfect, but we need to know where our weaknesses lie in terms of a knowledge base and know exactly where to point the party to, right? The known unknowns, and I can't re-emphasize this enough, very critical. A good lawyer knows the known unknowns. A bad lawyer doesn't know the known unknowns, right? He doesn't know the unknowns. And that's where all the trouble begins. Right? And the next leg of this will essentially tell you what it means, right? So for example, let's assume there's an IP licensing contract where the moral rights are also being irrevocably assigned. Under Indian law, it is not valid, right? But then what do you do tomorrow in case you want some flexibility with the moral rights, right? You want to play something or modify something without having to go back to the original author. You can't have it in the form of a irrevocable assignment, but you can have it in the form of a waiver, where you say, I'm paying you a sum of money not to enforce your moral rights against me. So structuring that moral right flexibility as a waiver as opposed to an assignment can probably make a difference between enforceability and non-enforceability, right? So sometimes the party may come back and tell you that the business case is this, but you are the lawyer. You have to determine if the business case is even enforceable and tenable or not. The case in point being the greeting customers with a smile. The parties were completely convinced that this is transfer of technology, but your job as a lawyer is to weigh in and say this is not possible. That 500 times or 2,75,000. The business case the parties have agreed upon, but it's your job to say, hey, look, this is not enforceable. Let's come back with something that's workable. Right? Sometimes the parties will have a very convoluted and complicated approach to the transaction. You have to then tell them, look, this won't work, simplify it. Right? So the role of a lawyer is not just to take what the client provides and put it on paper. The role of the lawyer is to counsel the client. Right? You're not just a glorified typist. You're a counselor. You have to advise them and give them the correct advice. You have to pull out the information from them. You learn cross-examination as a lawyer by talking to your clients and getting information out of them, because they won't know what's relevant. You have to essentially get it out of them. Right? So taking the time, effort, and energy to work with the client to assess the business case and the tenability of it is 90% of the problem statement when it comes to a contract. Right? And going back to the next point about the need to know everything all the time. Ease of enforcement, and I can give you another example. We had a situation where we were working on a joint venture for a technology company, which was going to be set up in Turkey, right? This was going to have potential, applications in the defense sector. And one of the things that happened at the same time was the attempted coup against the president of Turkey back in the day. And the question that came to us is that should we scrap the deal, right? Is there going to be the kind of political unrest that rises to the level of a force majeure. Right? And one of the things we had to do as councillors was also to assess the political landscape of Turkey at the time, determine if the client should be advised to terminate the contract, whether there are sufficient grounds to terminate the contract so as to avoid a potential arbitration, and to ensure that the termination is actually legal and proper. So our research into that entire query was 50% into the law, 50% into understanding the socio-political fabric of Turkey at the time, right? Again, goes back to the point of how there is a need to know everything all the time. Last but not the least, you want to assess the ease of enforcement. IP licensing agreements or IP assignment agreements, transactions in IP suffer stamp duty. The Karnataka Stamp Act has specific provisions for stamping stamp duty payable. Stamp duty not paid, even a non-disclosure agreement could mean that you're paying 10 times the penalty applicable on the non-disclosure agreement, right? Without which it's not enforceable. Sometimes the IP transaction will have to be compulsorily registered with the IP office, like for example, patent assignment and patent license. Trademark assignment without goodwill, right? If you don't register it, enforcement becomes difficult, right? If you're not a registered assignee or a registered licensee, you have a problem. If you are a licensee for a foreign software and there's infringement and you want to take action, you can't take action as a licensee unless you are exclusive to the point where even the owner of the IP abroad can't come and do business in India without your permission. Right? So knowing all of these things will be very critical to determining enforceability. And last but not the least, as part of the role of a counselor, you have to emphasize the need for fairness in the agreement. That 500 times of 2,75,000 is exactly the point. Yes, you don't want the parties to be watching the agreement, the video more than once, but you need to enforce or put in place a clause that will ensure that it is fair, it is enforceable. Because what is not fair will generally not be enforced. Courts in India are also armed with something very, very beautiful and abstract called equity. So sometimes equitable considerations overwhelm the considerations of the contract. You might just have a perfectly well-drafted agreement fall in favor of equitable considerations, right? So having fairness and clarity is really important. Okay, so I'm thinking that we are dangerously running short of time, so I'm going to quickly rush through the next segment, right? So essentially what you need to keep in mind is IP is never static, it keeps evolving. So your agreement should also address not just IP in its present form, but IP as it changes and evolves. And the best example is the Google and Uber dispute over trade secrets, right? Which is because a guy who worked on Uber self-driving car technology has enough skill set to take it forward to Google and then contribute to Google's efforts in developing self-driving technology. He may take a different approach altogether, but there could be accidental use of IP assigned to Uber when he jumps to Google, right? Now, addressing these things in a contract is not easy. So that's the reason why you take the time, effort, and energy to avoid templates and then examine the specific needs of your client and then define these clauses, right? If you don't do that, chances are that these kind of disputes may become very difficult to address, right? So I'm going to quickly jump to the next one. So now I would have ideally wanted to do this as an exercise of drafting the agreement, but the reason why I'm taking the non-disclosure agreement as an example, non-disclosure agreements perfectly enforceable, no problems. But sometimes what the parties do is that they very slyly introduce a non-circumvention clause or a non-compete clause. A non-circumvention clause, for example, if you and I are going to enter into an agreement to bid for a contract, we have a non-circumvention clause in the non-disclosure agreement, and the non-disclosure agreement only is for the purpose of saying that tomorrow you and I will enter into a consortium agreement to bid for the technology project, right, to supply software to the Indian government. Before we have the consortium agreement, we need to know each other. For that purpose, I'm entering into a non-disclosure agreement. No money is exchanging hands, no definitive business is offered or promised. Now, in this pre-business non-disclosure agreement, there's a clause that says that you will not circumvent me or you will not compete with me for this stream of business. Right? The enforceability of that clause is going to be highly suspect, because for the mere exchange of confidential information about the party's abilities, talent, capacity, can you come back and impose a restriction on my entire ability to do business? Is there sufficiency of consideration under Section 27? Probably not, right? Then it means unreasonable restraint of trade. Now, what happens when the non-disclosure agreement contains these kind of clauses is that the enforceability of the overall agreement gets diluted by these unenforceable clauses. So tomorrow in a potential dispute, say in the US jurisdiction, if I was the defense counsel trying to avoid the agreement, I would argue to the jury pool that please look at the non-compete clause and see how predatory this agreement is, right? It's the big guy trying to trample upon the small guy. And that's probably sufficient for the jury pool to ignore everything else about the agreement and say it's not enforceable, right? The Apple versus Samsung patent dispute, one of the arguments that might have swung the case in favor of Apple was the narrative supplied by the plaintiff counsel that Asian companies are destroying American businesses, right? It was an argument that won the reproach of the court. They said you can't influence the jury pool in this manner, but possibly the damage was already done. So ensure that the fairness is well reflected, because sometimes when you have clauses like non-compete and non-circumvention, the first spidey sense that should tell you that this is a red flag is the fact that it sounds a little unfair. If it sounds unfair, chances are that it could be unenforceable. So always keep your eyes and ears open for it. Never rush into these things and never go with statements like it's part of a standard template. Everybody else in the industry is doing it. That's the most common thing I hear. Everybody else in the industry is doing this. 100 other companies can make the mistake, but it's your dispute that's going to cost you, right? And the objective of the agreement is to ensure that you don't make the same mistakes everybody else is doing. So just an illustration of ensuring that what is realistic for that agreement is what you put into that agreement. If today business terms and conditions are not negotiated, there's no clarity, no point in introducing a non-compete and non-circumvention clause within the NDA, right? And then it only just complicates the entire agreement even more. Dispute resolution, like I was telling you in the beginning, know where you're going to agitate the contract, where you're going to try and enforce it. Have realistic dispute resolution clauses. If a simple non-disclosure agreement without there being any business in sight has a 3-member arbitral tribunal specified for enforcement, it is overkill. You will spend so much money for enforcing that agreement, it's not even worth it. So then you want a sole arbitrator or just a jurisdictional court sitting over it. Know where you're going to do it. Is it going to be London Court of International Arbitration? Will it be DIAC? Will it be SIAC? Each institutional arbitration center has its own strengths and limitations. There are international commercial courts now, SICC and DIFC, which could be a cost-effective alternative to arbitration centers. Right? So depending upon what your client's capacity is, means are geographical locations. So sometimes when the party is in Europe and one party is in Asia, the neutral venue to meet to debate the agreement would be Dubai, right? DIAC. But if one party is located in, say, Australia and the other party is located in India, maybe Singapore International Arbitration Center or Singapore International Commercial Court makes more sense, right? So you also have to look at arbitrability of the dispute in the IP law. Very, very nuanced and complicated jurisprudence. So, for example, confidentiality agreements, joint research and development agreements involve colors of IP enforcement and contract enforcement. If it's a pure and simple IP enforcement action, sometimes they're not even arbitrable. Right? So you'll have to figure out these things before you stipulate a dispute resolution clause, right? So depending upon what it is, it's either a court of law or a alternative dispute resolution. If it is alternative dispute resolution, location cost will determine if it's Singapore, Dubai, London, arbitration, international commercial court. All these things you'll have to kind of define in your agreement. So to conclude, right? Your job as a lawyer is not to transcribe the agreement for your clients, right? Whatever the client has agreed upon, it's not your job to just put it in paper as it is. Your job is to counsel. There's a difference between transcribing and drafting an agreement. Your job is to draft. Application of mind being the buzzword here. You need a fair contract to be defined, because what a fair contract does is it shortens the time for the parties to close the agreement, ensures greater enforceability, reduces legal risks, right? Value of a contract is defined by a variety of factors, but more often than not, it's determined by one factor and one factor only: enforceability. More enforceable it is, more valuable it is. Always remember, there is always a better way to put across a contractual clause. I go back to contracts that I've drafted in 2012, and sometimes I wonder, why is this contract drafted as poorly as it is? Right? Because as the law changes, as times change, your drafting skills and approaches must change. Right? Previously, 40 years back, the closing arguments in the average trial in the United States would go on for maybe 2 to 3 hours at ease because the attention span of people was not affected by Twitter and social media. Today, it's 20 minutes. Closing arguments can't be for 2 hours. Right? So same thing with contracts. Contracts at one point in time could have been voluminous because people had more ability to read longer documents. Today, that may not be the case. You need to put it across in short and crisp manner. So therefore, you need to also innovate in the way you approach contracts. The other thing is there's a lot of innovation happening in the field of drafting of agreements itself. Contract visualizations are a great tool. I have personally seen an undertaking signed by an employee to comply with the sexual harassment guidelines. That entire contract is in the form of an explanatory cartoon, right? And he reads through the entire cartoon, which explains what is sexual harassment, why it is not okay, what are the means put in place by the office organization to ensure it is dealt with. So this entire thing is in the form of a cartoon series. He reads through that entire comic, and then at the end of it, he says, I have understood the terms of the policy, which is already a document that is provided to him separately. And I have read through the depiction of that contract in the form of this comic book, and I agree to abide by them, right? Very innovative, especially when you have, for example, a requirement of data assignment. Today, you need informed consent to process data. And informed consent has to be not just consent, but informed consent in the language that the person understands. If India has 20,000 languages, getting informed consent for data processing for a loan in the agricultural sector is a nightmare. And if you have to draft that agreement, it is challenging. But suppose you do this in the form of a audio video cartoon, playing to the person saying, this is the data I'm collecting, this is why I'm collecting it, this is how I'm going to process it, this is how long I'm going to retain it. Can you please watch this entire thing and tell me if I'm okay with it or not? You have essentially gotten an agreement, not in a standard text form, but in the form of an audio-visual contract, right? So there are many ways in which you can innovate. So never be limited by what traditions tell you when it comes to drafting of agreements. The only thing you need to keep in mind is enforceability, simplicity, ease of understanding, right? The other thing is smart contracts. Now, this is an innovation in blockchain where these contracts are self-executing. You comply with condition A, condition B automatically is performed, right? Now, to ensure that contracts of this nature are capable, you need to structure the transaction in a simple manner. And a good 50% of our job as contract lawyers is firstly structuring the transaction in a simple manner, and thereafter reducing it in the form of a contract. Right? So being abreast of these technology innovations is very critical, because sometimes there is always a better way to put it across statement is performed not by typing the clause better, but by employing these kind of innovations better. Right? So never stop innovating. It is a lawyer's job to innovate as much as it's an engineer's job to innovate these days. Right? So with that, I think we come to the end of the session. Thank you so much, and sorry for overstepping the time.
No, that's okay. That's okay. Thank you, Ashok. Thank you. This was a great session and a lot to learn, in terms of how you innovate in the context of contract drafting. It's not just learning the basics of contracts today, but it's a lot more beyond that for lawyers, those who are stepping into the profession of law. This is a great time for you to learn innovation and innovative techniques in drafting contracts. And it was also a great learning that contract is a communication. Contract is also imagination. So these are some of the key takeaways that we've had. And Ashok has brought in a very important insight of drafting contracts in the lens of governing law, jurisdiction, and most importantly, the commercial objectives. Thank you, Ashok. And should anyone have questions, any more clarifications regarding the subject, Ashok is, of course, going to be here for the later part of the session today, the session on technology transfer and know-how. Apart from that, you could also write to us, and we will keep you. We will get Ashok to a conversation later, sometime later, on any clarifications that you have or any communications that you would like through with Ashok. And of course, he has also shared his email address and contact details. You could connect with him. Thank you, Ashok, and we look forward to the next session. Thank you.
Thank you. Thank you.
And participants, we will break for a short while now. It's about 11:15. We will come back at 11:30 for the next session, that is on IP transfers. So Ms. Sheetal will be joining us soon. Thank you.